Hello, everyone, and welcome back to the.universary. Today we have a couple of really interesting cases for you. The first is Sean and Michelle Larkin versus Dean Coots. This is before Judge Meyer in Thurston County, Washington, and like the card says, I really feel like this belongs on an episode of World's Worst Neighbors. The level of upset is very, very visible on the litigants' faces, and it's just really unfortunate because this is where they all live and this is the situation that they have. Let me know your thoughts. Hope you enjoy.
So Mr. and Ms. Larkin, you could come on the Zoom call, please.
They're ready.
So who's gonna speak first?
I can.
Okay, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, so you're asking, there's a counterclaim filed in this case. Mr. Coots has filed a counterclaim. Both of you are seeking, I think, let me call this up here. Both of you are seeking jurisdictional limits against each other in the amount of $10,000. And if I understand your claim, the Larkin's claim correctly. Just a minute, my computer's acting up here, and for whatever reason, it's not opening the case like I wanted to. I did read everything. There was a brief that was filed at Superior Court that was submitted. I reviewed that, which kind of ran down. I kind of remember this case. I think I may have heard the temporary order. I know Judge Buckley heard the full hearing, signed an order, was in place for 2 years, still in place now, as far as I can tell. It's set to expire in April. In any case, and ma'am, if I can understand your claim correctly, Mr. Coots and you folks live very close, if not next to each other out there, and here in Thurston County. And there's been a lot of conflict over the past period of time. An order has been entered. And if I'm understanding this correctly, you did a lot of things as a result of your position as a result of the way Mr. Coots has conducted himself. You've had to do a lot of things to your property, including putting in fences, surveillance equipment, things of that sort. And basically you want him to pay for that. Is that the long and the short of what your claim is?
Yes.
Yes, Your Honor.
Okay. Okay. Anything you wish to add to that?
I think just from us always having to be on guard and not allowing ourselves to enjoy our land the way that we should be able to, or have our kids be able to go across the street. We always have to worry about them when they go to school, or when they come home. A lot of times we drive them. We feel like we're being watched and hunted. And we found Jean's card and
I'll talk. And we just filed a plea.
Well, if you're going to talk, I'm going to swear you in first. You raise your right hand, please.
Yeah,
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
yes.
You can put your hand down and go ahead. And like I say, I don't want to, and I will tell you, this is not an anti-harassment hearing.
Yes.
I'm aware of the background, but I need a legal theory that allows me to give a judgment in your favor. I just want to be clear about that.
Okay. We had to erect a fence. We had to put up the security cameras. Him and his ex-girlfriend / caretaker, they still drive by. They still look in. This isn't, it feels like we're in a prison, but we had to do this to at least to protect ourselves to some extent, as much as we could. And just 2 weeks ago, we found Jean's credit card in the bushes. We did file a police report with that. So
I saw that.
And then it shows that they're still there or doing something. This credit card doesn't get in the bushes, so it must, I don't know, I could only speculate that it fell out of her pocket. I don't know. And then we just found out by the mediator, he's still contacting the state and the city, filing complaints against us. This is ongoing. If he did it on January, was it 22nd? He just contacted the city and the state again on the 22nd. So this is still ongoing. We're trying to make peace. We have been for 14 years and our hands are tied. I tried to contact the sheriff, FBI about the guns, and it's nowhere. So, I mean, we could only do so much. So we had to put up a fence. We didn't want to. We had to put up.
To bring up the.
Yeah,
He had many opportunities to show that he relinquished the guns. And at the first hearing with you, Your Honor, you informed him that the sheriff did advise you that he had 17 registered guns at that point. When it was seen before Judge Buckley, he never once gave any evidence that the guns were gone. So we have to protect ourselves as best we can because there's nothing else. We can't just have him to be able to view right into our house. So we had to make a solid fence just to keep him from stalking us. And they're still stalking us. And it's just never going to end. We feel he's very dangerous. I've seen him lose his temper several times, and he's tried to access our land through our driveway. I've been in my van with him hitting my car with a stick and swearing at me. I've had so many things happen from him, and I just want to be safe. And I can't be safe.
So let me hear from Mr. Coots. Did you raise your right hand, please?
Yes, Judge.
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. And then you're asking for a counterclaim in the amount of $10,000 also. I guess, what's your basis for that?
That because of their testimony to the courts the last couple of years, I have lost my Second Amendment rights, and it's cost me a considerable amount of attorney fees to fight the allegations. And at this date, I lost my fight for my Second Amendment rights. I believe that the allegations were all false that brought us here to this point. And I've just have spent, I originally got a lawyer. I think that was actually a mistake. Not because I lost, but it's just, I just felt that the district court maybe frowned on that at the time. And, but I do feel that, that everything that I have, that it's the monetary cost to me to this point has been considerable.
I think it's been considerable to the Larkins also.
Yes, sir.
I mean, because my understanding is, and from reviewing the paperwork from the anti-harassment order, they had an attorney too. And so both folks had attorneys. And, one thing I will say, we don't decide cases based on whether or not someone has an attorney or not. We listen to the testimony and decide, and I didn't decide this case, but pretty confident Judge Buckley didn't decide the case just because one person did or didn't have an attorney. You listen to the evidence, you listen to the testimony, then you make decisions, as I kind of said in that opening statement, for right or for wrong, based on what the evidence is and what the law allows. So I do want to, let you know that your case was not decided based on whether or not you had an attorney or not, but you may continue.
I don't have anything else to say at this point.
All right. So, here's, I went through all this stuff. A lot of stuff had been filed on both sides. And, as I said before, that order's in place. It's been in place since April of 2022. It will expire, scheduled to expire on April of 2024. Could bring a petition to renew it if you wish. But that's not in front of me here right now. The only thing that's in front of me now is the Larkins are asking for compensation for improvements they made or things they did to their property based on the behavior of Mr. Coots. Mr. Coots is saying, well, I incurred a lot of expenses based on, things the Larkins have said. And, with regard to both of you in this particular case, and this might be one of these situations where everyone's upset with me following the trial, but I just can't get there from here. I can't come up with a legal theory that says, you're entitled to a judgment based on, you make improvements to your own property, get somebody else to pay for it because they're a bad neighbor or even a terrible neighbor and a horrible person, and they've done all these things, but there's not a legal theory that allows me to make him pay for it. And I just can't do that. Same is true with regard to Mr. Coots. He's incurred some expenses based on all of this. He may be at fault. I don't, Judge Buckley did see fit to enter an order, but he's not entitled to be compensated for any of this stuff either. And so I'm not going to award a judgment in either party. This case is going to be dismissed without costs or without a judgment to either party. But this isn't. There's just, like I said, particularly to the Larkins. I just can't get there from here. I can't come up with a legal theory that allows me to enter a judgment in your favor for the things you've done. I just can't do that. And so I do sympathize with. I don't think it's very pleasant for anybody out there, which is terribly unfortunate. Mr. Coots has said he's lived out. I know he said in his things he had submitted, he's lived out there for a number of years, over 20. I can't remember how many. Ms. Larkin, I thought I heard you say you've lived out there for 14. So I don't, I hear from both of you what it's been like out there, and it's obviously terrible, but I can't, I don't have a basis to enter a judgment. And that's where I'm going to leave it for today on this case. You both are free to leave the Zoom call.
Thank you very much, Judge. Thank you very much.
Okay, so our second case isn't much of a case at all. In fact, the only part that is worth watching is the introduction by Judge Middleton. Hope you enjoy.
We're going to take that one first. Is entitled White Pigeon Township versus Noah Livingston. The file number is 24151SC. Their township manager, Jean Teft, is here with us. Good afternoon, Ms. Teft. Would you please raise your right hand? You swear or affirm to the best of your ability you will interpret these matters from Spanish into English and English into Spanish. Oh, excuse me. I forgot what the heck I was doing. Do you swear or affirm that any testimony you give in this matter will be true to the best of your knowledge and belief? All right, you need to unmute your mic. I don't need a translator here. I can't hear you. All right, Ms. Tuff, can you hear me now? You still have no mic.
Okay, good. I'm sorry.
All right, now we've got a feedback loop. But we'll struggle through this. All right, the title of the case is White Pigeon Township versus Noah Livingston. This is a claim regarding a action that the White Pigeon Fire Department went out on. Mr. Livington was served by certified mail. The claim is for $284.90. Is that correct, Ms. Teft?
Yes, that is correct.
Anything been paid on that?
No.
All right, he's not here. We've dinked around for about 6 minutes and he hasn't appeared. By default, I find that he's responsible for that claim of $284.90. There's $43.65 in court costs for a total judgment of $328.55.
Okay.
All right, I've signed that default order. And we'll send it to you. As you know, getting the judgment is the easy part, getting the money is the hard part. But you've got your judgment and you're good to go on about your day.
Okay, thank you, sir.
All
You
right,
have a
thank
wonderful
you.
day.
Okay, bye.
Bye.
All right, so we have one more case for today. This is before Judge Meyer, and it is Mr. Staub versus Ms. Pratt. Mr. Staub and Ms. Pratt were in a relationship. He proposed and gave her a ring. She is now claiming that that was a promise ring, not an engagement ring, so he doesn't need to get it back. All right, hope you enjoy.
Ms. Pratt, just come on up and take a seat. Mr. Staub. Pull your case up here. Mr. Staub, could you raise your right hand? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
So you're asking for a judgment in the amount of $1,886.56. It says for multiple items on the list, and then you have submitted a list of things,
Correct, Your Honor.
handwritten list, which I've looked at. And hang on just a second. So how is it that Ms. Pratt owes you this money?
Well, Your Honor, we entered a relationship and became mutually intimate. I soon after proposed marriage to her. Jody accepted my ring as a gift proposal. Shortly thereafter, went to the store where I had purchased it, had it sized. There's documentation there that has both my name and her name on that said gift proposal ring. There's some other things, and then our relationship, Your Honor, was we both had equal faults, and it was mutually a very up and down ride for about a year and a half. And now when I asked the ring back, she did not give it. When we finally did separate, there's some items on here like a car title. She had taken a car title from me. Told me that she was going to report the car stolen. I had accidentally signed that car title, so I had to go to the DMV and get a new car title. She refused to return my keys, told me that she had thrown them in a dumpster. There's filing fees that I sent. I had to change the locks because I wasn't sure whether she did actually throw the keys away or give them to somebody else. So all these small things that they added up to. There's a big chunk of it for some medication. In mediation, she had stated that she had returned an epinephrine pen medication to me. This was true at that point because she had taken them before. We were in a relationship that would go a couple weeks and then off a couple, and until it finally became to where the demise is over. Please give me the back. The epinephrine pen and the inhaler that she took from me this time came to $624.37. That is not money that I spent, nor do I anticipate I'm trying to collect for that. However, all the other costs for the phone that I purchased right when we first got together, hers was cracked. She stated that she wanted to have a picture of me on her phone. And I said, hey, as long as you're my girlfriend, I will get you this phone. But if you leave me again, then I want the phone back as well. So that's also in the costs. The other tough one that I have written down is 2 months storage. She had gotten a job at one point, and stated to me that she would pay half of of our water and power bill. We didn't pay rent where our lot is. Just had to pay our own water and power. She come payday, she never helped out with it, and I struggled to help support her. She never contributed financially to our relationship. So I have it written down as 2 much storage, which she's still got stuff there that I can't throw away. She left all her clothes there. I washed them, dried them, folded them, put them in boxes and delivered them to her place of choice. But she still does have some items on that said property. Other than that, Your Honor, I just, that's the small amount. The most important was the ring that was not returned. And I believe she sold it. She can't provide it for me and refuses to give it back. I've asked her a dozen times probably to have the ring back, and she said no. I believe that sums it up, Your Honor, unless you have any other questions.
I might in a minute.
Okay.
First, I'm going to speak with Ms. Pratt. You raise your right hand, please. You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. What's your position on his request?
As far as the medication he is talking about, he had given me 2 EpiPens because I had ran out. I'm allergic to bees and I couldn't get any at the time. When we broke up, I returned those to him. As far as the title to the car, he was supposed to give it back to me. He signed it. I was going to take it in and have it switched back into my name. Before I could do that, he went in and applied for a lost title. So I threw the other title away. It was no longer any good.
Whose car is it?
It was my car at one time. And then I did not have the money to have it put into my name. So we had to put it in his.
So he has the car now?
He has the car now. He would never return it to me. He was going to.
Right.
He had signed the title. I had the title. I was going to take it in. But before I could do that, he went in and had it put back into his name on a new title. He applied for a lost title.
What's the story on the ring?
The ring, as he stated to begin with, it was a gift. Yes, we did get engaged. I broke it off shortly after that. We had split up. We got back together a couple weeks later. He went out and bought me the ring. And it was a promise ring that he would quit drinking and quit torturing me by calling me filthy names, degrading names. And we split up a couple more times after that. My bad was I went back to him again. The last time was the last time, and that was 9 months ago. As far as rent, like he said, he never paid no rent. The power and water, he had just gotten hooked up. I had left a month after he had just gotten everything hooked up legally to pay for it. So I do not feel that I owe him anything.
Where's the ring now? Do you still have it?
No, I do not.
I don't know what the dog's going after. I guess he's trying to check out.
Go ahead and mute that, please. Mr. Let me just a second. Mr. Staub, anything further?
No, Your Honor. I stated my case there. I don't believe it's relevant. The car was never in her name. I cannot prove how much money that I paid in cash for her and how much money she's taken from me. So that's not on the list. I just put what I know, and I really feel that is provable income on this request for judgment, Your Honor.
So am I missing something? The price of the ring?
The price of
I
the
see
ring is $764. There, you should have a receipt there, $764.70. You have
I
a repair information on the ring. That's when she took it in to have it sized to her finger.
Right, I have that, but I don't see where I don't see where you get the 764.
Oh, I filed a set of receipts, one from Fred Meyer.
Okay, I was looking at the wrong place. I saw the Lowe's. It's next to the Lowe's. Got it. All right. So ma'am and sir, I'm just going to read to you something that's basically kind of, for lack of a better term, law of the rings. In California and Washington, an engagement ring is a conditional gift. I mean, it's being a gift as a condition. And till the wedding is legally the property of the person who gave it. So the ring is given as a condition that, we're going to get married. If the engagement, breaks off, then it needs to be given back to the person who gave it. And so you're telling you don't have it. I do see the value, what the cost of it was. The other things he's asking for, I'm not going to award them. The EpiPen and all that other stuff. But given that this was given in that manner, give me just a second here. Yeah, but I don't know. I'm going to enter a principal judgment in the amount of $764.70, and then there'll be a $50 filing fee, and that'll be it. And then I'm not awarding for anything else. Give me just a minute, ma'am. We can give you a copy of this before you go. This is the wrong one.
Your Honor, did I understand that you're ordering that $50 filing fee to be awarded to me as well?
Yes.
Okay.
Total judgment amount is $814.70. And once you make a copy of that, Mr. Staub, you can get that off the district court website. Once you get a copy of that, you're free to go, man.
And when will that be available on district court website?
Oh, maybe an hour or two. Yeah, that's right. We have an in-court clerk. He'll take